apologies for being a bit late. As you can imagine, we've been discussing the case. Yes.
My lords, my lady, the matter of the formulation of the question of law,
Yes.
I was planning to come back to it at the end.
Fine.
For one thing, we've had a proposal this morning from the sellers, which runs to 10 lines, and appears at face value more to obliterate the original question than to refine it. For another thing, it may be that by the time one gets the end of the submissions, the court will be better placed to think about how potential formulations actually tie in with the issues which are being argued.
Yes.
So, I was going to begin...
The cases I had in mind, which I referred to in my judgment last year in Sharp and Viterra, if you haven't found them, were Cotton Text for Mr. Justice Hanlon and the Mahakam for Mr. Justice Eden.
Both sides have looked at those overnight, I think.
I think you have on your desk our formulation of the question, obliterative or not, sort of handle with care, and also a copy of the judgment which you've just referred.
I've got Royal Sun Alliance.
It's even more up to date than Viterra, but it refers to Viterra,
which quotes Viterra,
which quotes the other two.
And we've redlined your.
It's amazing how quickly one can forget the cases one's been in. There we are. Thank you. Which page is the red line? Page 1664, is it? 1662. Thank you. Thank you.
So, I would like to begin this morning, if I may, with the formulation of the question of law as the sellers put it to the tribunal, which after all underpins this appeal, because the reason we're all here is that the formulation which the sellers put to the tribunal was accepted by the tribunal, and the question before the court, as guys, is whether they were right to do so. Now, that formulation, we looked at it yesterday. It's paragraph 29 of the reasons. It's page 85 of the bundle. And it's the general principle which is set out by Akai. Then Leonidas doesn't take matters any further, it just states what the cases say but doesn't actually decide anything about it. Now, on the question of formulation, I just would, while we're at it, just ask the court to note that when they were putting their case to tribunal, the sellers were perfectly content to express it, their proposition, in orthodox debtor-creditor two-party terms. They did not think it incumbent to confuse matters by highlighting that in the particular context of this particular contract, the deposits were to be paid in the first instance to a stakeholder. That's not mentioned. And I suggest that that's no doubt for entirely sensible reason that they recognised that if the general principle didn't work in a two-party case, then there was no basis on which it was going to work if you interposed a stakeholder. And indeed, the court will have noticed that nothing which my learned friends have said about the general principle, either orally or in writing, hinges upon the fact that there was a stakeholder in this case. It's an extraneous consideration. Also, the court will note that in formulating their proposition of law before the arbitrators, the sellers equally did not feel it necessary to confuse matters by hoisting in what my learned friend explained to you yesterday as the two-stage process by which they contend that the deposits were not only payable, but also became forfeit. And that is no doubt for the sensible reason that, as my learned friend explained to you very carefully yesterday, the general principle is only relevant to the first stage in the two-stage process. They rely upon the general principle to say that the deposits became payable. Now, if the deposits didn't become payable, they can't have become forfeit, and stage two never arises. If they succeed at stage 1 and the deposits became payable, then their stage 2 argument that the deposits became forfeit does not rest on the general principle. General principle is spent at stage 1. The forfeiture argument rests upon the contractual termination clauses, and in particular the contractual termination clauses as they have been interpreted in the Griffin.
Which we are bound by, and you don't ask us to.
I don't ask you to.
Which do you reserve the point in case it
I
goes?
do. I reserved the point, and I was going to say something already about that, and I got the impression yesterday that the court had taken the point firmly on board, so I was proposing not to say anything more about it, but I do reserve.
That's what I understood from. Yes.
I'm grateful that your lordship's got that. So the stage 2 doesn't depend upon a batch, and so the sellers were content to put the point of law before the tribunal in a fairly concise form, certainly rather more concise than the formulation which has appeared this morning. Now, just sticking with the general principle as put to the tribunal, the important word is deemed. At the risk of stating the obvious, the satisfaction which is referred to at the end of the principle is not an actual satisfaction in fact. Because if the condition precedent has actually been satisfied in fact, then the debt becomes due and payable according to the wording of the contract on ordinary principles. And there is no need to resort to any separate principle based upon a Batcher, Mackay and Dick. It just becomes due in the ordinary course as a matter of construction. And equally, the waiver which is referred to in the principle is not an actual waiver in fact. For the same reason, if on the facts of the particular case a condition precedent has been waived in fact, then the condition precedent can be dispensed with on perfectly ordinary orthodox principles of waiver. There is no need to have resort to any general principle based upon Mackay, Abacha, or anything else. Now, to point which Mr. Justice Foxon does make in the Lay and Ilas, there will be cases in the area of conditions precedent where the facts do admit of an orthodox waiver in fact interpretation and analysis, and where the case can be explained on perfectly orthodox principles of waiver without having resort to this general principle. And we have an example in the bundle. It's the case of Tybergian and Greenberg. Since it's illustrative rather than key, I was hoping not to turn it up in detail, but for your note, it's tab 11, page 156 of the bundle. It's a decision of Mr. Justice Devlin. It was a sale of goods to be exported from France to the UK. Mr. Justice Devlin found that the payment terms were 30 days after invoice. Now, he doesn't expressly go into this point, but that may have meant that it was a section 49.2 of the Sale of Goods Act case where the price was payable on a particular day regardless of whether title had passed. But Mr. Justice Devlin said that he was going to consider the case on the assumption that the buyers were right, that the price wasn't payable unless and until the sellers had delivered the goods to London. He was going to give the sellers the benefit of the doubt that that was the correct approach to take. And what happened was that the sellers were able of their own steam to get the goods as far as Folkestone, but they couldn't get them to London unless and until the buyers, and only the buyers could do this, completed some customs formalities and made certain customs payments. And the buyers didn't do it. And then the buyer said, you haven't got the goods to London, and therefore you're not entitled to the price. And Mr. Justice Devlin concluded that the sellers were entitled to the price. He refers to Mackay and Dick. He doesn't really go into much detail about what he gets out of it. But the way in which he ultimately expresses his conclusion is that the buyers had waived delivery to London. Page 161 of the bundle waived delivery, quote unquote, that is what it amounts to. That is to say, that's what happened on the facts. Now, we know from the Canton Jugal that whether there's been a waiver is a question of objective interpretation of who has said or done what.
Well, I wonder if that's a fair characterisation of his reasoning. He spends quite a long time discussing Mackay and Dick, and then he says, assuming that delivery is a condition precedent payment of the price, then for the reasons I've already given, that's Mackay and Dick, the defendants can't rely upon the defence the goods were not actually delivered in London.
Indeed, my lord.
The non-fulfilled, they can't rely on the, it's not now open to them to set up that condition.
Yes.
Therefore, the point fails.
But
And so he's treating the Mackay and Dick principle, isn't he, as giving rise to a waiver. But he's not saying there's a waiver in fact.
well,
And therefore, the Mackay and Dick principle is of no relevance at all.
he does indeed set out the Mackay and Dick principles. As I said, he begins with it at 160. There's another case called Motor Oil where he considered the Mackay and Dick case in quite a lot of detail. And he'd said, as we say in our submissions, that there are two ratios, my Lord Blackburn and Lord Watson. And there's not that sort of detailed analysis of Mackay and Dick in this case.
No. Well,
There's reference to it.
maybe so, but
He doesn't really.
he'd been counsel in Palomina. He was well aware of what Mackay and Dick was regarded as authority for, whether rightly or wrongly. And at column 1 at 744, after he's been discussing the matter, he says about halfway down, the course the defendants took was not only not to pay the duty, but to give no instructions whatever to DeForest, which on the evidence was essential to be filled in so that the goods might be entered so they might be forwarded to London, either in bond or with duty paid. They did none of these things, and their failure to do these things, which by necessary implication of the contract they were required to do, was the reason why the sellers were prevented from tendering the goods. Accordingly, in my judgment, for the reasons I've given and on the principle of Mackay and Dick, the defendants cannot rely upon the defence that the goods were not actually delivered in London. And then he goes on to address, as you've said, the fact that the invoice, that the contract simply provided for payment 30 days after invoice. And then at the bottom of the page, says whether that, i.e. that's delivery, is a condition precedent or not, I need not determine. But assuming that it is, for the reasons I've already given, it is not open to them now to set up that condition, the non-fulfilment of that condition. Therefore, this point fails. In short, by waiving delivery, because that is what it amounts to, they waive their right to inspect and reject goods.
My lord, in my submission, that's the only point in which he really articulates the basis for the conclusion that he's reached, and he puts it in terms of waiver. So they waive their right to inspect the goods, that's what it amounts to. It's true he refers to Mackay and Dick.
Well, I think what Mr. Kinney would say is he's applying the Mackay and Dick stroke Abacha principle and saying the mechanism by which that dispenses with the need to perform the condition is waiver.
Well, my lord, if
There's been a waiver, in fact, therefore Mackay and Dick's got nothing to do with the question.
if he is saying that Mackay and Dick is authority for the proposition that a seller who has not delivered goods can rely upon some deemed waiver in order to recover the price, then he is making a decision which is directly contrary to what was decided by Mr. Justice McCarty in the Collies case.
Well, is that necessarily so? It may be a question of contractual construction and intention in any particular case. One may be able to say, well, in your standard FOB seller case, as Mr. Justice McCarty says in Colley, the parties couldn't possibly have intended that the seller should keep the goods and be paid the price. But in the particular circumstances of this case, Mr. Justice Devlin determined that having got the goods to Folkestone, they'd done enough because of the application of the Mackay-Dick principle for delivery, which was the assumed precondition, to be deemed to have occurred. Different cases involve different results, and it's a matter of contractual intention. Is that a way of reconciling them?
Difficult in my submission to see how the arises at the conclusion of the matter of the construction of the particular contract. Not the analysis which Mr. Justice Devlin engages in this case, any more really than Mr. Justice McCarty does in the Colley's case. Mr. Justice McCarty is stating a general principle. He stated very clearly his conclusion is that the price is not, setting aside section 49(2) cases, the price is not earned unless the goods are delivered. That is not a question of construction of the contract. It derives that from the case law. And equally, I submit your lordship is not going to find a sort of wooden capita analysis of the particular contract in this case, leading Mr. Justice Devlin to the conclusion that the parties had intended to depart in this particular contract from the ordinary principle as stated in Colley's. What he expresses the conclusion as being at 161 is waiver of delivery, that is what it amounts to. And what I would submit is this. If you look at what happened in the case objectively, not look at the contract and construe it, but look at the facts objectively according to the Canton Junge, then the case does admit quite readily of an interpretation that what the buyers were intimating by not doing their part to have the goods carry on from Folkestone to London was that they did not require the sellers to get the goods, the final part of the journey from Folkestone to London. They were content to go and make their own arrangements to collect the goods from Folkestone in their own time. And they were therefore waiving the requirement for delivery to London as a condition precedent to payment.
That's not based on anything they actually did or said, because they did or said nothing. That was precisely the point.
They did nothing. It's an admission rather than a doing or saying. Your lordship is quite right. But what they omitted to do was that which it was necessary to be done to get the goods from Folkestone to London. And omitting to do it could objectively be taken as an indication that they didn't require the goods to be taken from Folkestone to London. They were going to sort it out for themselves.
Why can it not be said that your clients were obliged to give the KYC information to HFW? They omitted to do it. Having omitted to do it, they've waived the requirement for that to be done.
Because any waiver, in fact, on the facts of this case, the sense of it would have to be that we were objectively intimating that we did not require any more to go through the stakeholder process. And we were content to pay the deposit instead direct to the sellers in the way which I think the standard NS form contemplates. It sometimes happens. In the Blankenstein, for example, the deposit's payable to the sellers. And it is simply not a tenable interpretation of the events in this case to suggest that that is what we were objectively intimating. The case has never been.
What were you intimating by simply?
What we were intimating, my lord, and it's really this is common ground, is that we were not going to pay the deposit.
Yeah.
We were not going to pay it to. We were not going to pay it to HFW, a stakeholder. We were not going to pay it to the sellers. We were not going to pay it at all. I say that's common ground because our position was that we were not obliged to pay, and we were not going to pay
because of clause 21.
The tribunal said we were wrong about that, but that was our position. And the seller's position was that we simply repudiated the contracts.
Yeah.
You can't spell out of that a waiver of the stakeholder requirements. We just weren't going to perform rightly or wrongly as the tribunal held. And
well, since you're not going to pay, there's no point in opening the account. I understand that. That's why you didn't return the forms. But I don't, at the moment, see why, when it turns out your obligation was to pay, and hence it was to open the account, because the clause 21 point turns out to be a bad one, why it can't be said, just as in the Tibergian, that you have deliberately not complied with your obligation to do what was necessary to open the account, so you've waived the requirement that that be done.
Because repudiation of a condition is not waiver of a condition. Repudiation is not waiver. Repudiation is breach. Waiver is saying we don't require the thing to be done. We don't require, in Tibergian, we don't require you to get the goods to London. We don't require you to perform that obligation to get the goods to London. What we were saying in our case is we are not going to perform our obligation in the tribunal, in construction of contract. We are not going to perform our obligation to open, to help the stakeholder to open the deposit. And furthermore, we're not going to pay the deposit.
Well, that's all the buyers were doing in Tibergen. They're saying we're not going to provide the documents that are necessary to enable you to get it to London.
And it was to enable the sellers to perform their obligation to get the goods to London. And an objective interpretation of that can be, we don't require you to perform that obligation. But we're not, in this case, concerned about saying to the other side, we don't require you to perform an obligation, we're going to excuse you from that obligation by waiver. What has to be said is that we are waiving our right to have a stakeholder system put in place for the lodging of the deposit so that the money is protected. What has to be said is what we're saying is we're prepared to waive that, and if we waive that, then the money become, in ordinary way, become payable to the seller as a deposit. Yes, anything like that. It's just not a tenable interpretation of what we were saying. We said we weren't going to do it at all. So
Well, you
it's
can-
W to the sellers, to anybody else.
In any event, you can say the tribunal didn't find a waiver in fact, and the appeal is not proceeded on the basis
tribunal did not find a waiver, in
there
fact.
having been a waiver in fact.
They didn't find a waiver in fact, but
But-
there was a suggestion there had been, and in my submission, quite obviously, rightly not.
The point my lord was putting to you was as I understand it, more directed at how you say our facts differ from those in Tibergen, so that there would be a waiver in fact in that case, even if that wasn't what Mr.
Well,
Justice Devlin said.
Well, I don't want to labour it,
and
my
not in
lord,
this
but I
case.
do simply say that it is open to interpretation on normal principles that what you've got in Tibergian is a waiver by the obligee of the obligor's obligation to get the goods to the final stage.
Yes, it could have.
That is,
Mr. Justice Devlin could have decided on that basis,
and
but
that's an
but,
explanation for the case, and it means that
but he
there is no difficulty arises with how you reconcile it with colleagues. The other way of saying you can reconcile it with colleagues, of course, is to say, well, it was a Section 49(2) case. The price was earned 30 days after the invoice, and therefore it's a case about accrued debt and payability.
but again, not decided on that basis.
Not explicitly put on that basis, but that would also
Well,
allow us to
explicitly put on the opposite basis, because this is assuming that delivery was the condition for the price.
Well, condition of what is the question, my lord? Condition to what? Condition to accrual or condition to payment? Now, if one says it's a Section 49(2) case, then the price is earned when the date comes, but you could still have a provision that it won't become payable until later. No reason why it couldn't. Say it's a Section 49(2) case. The price in principle is earned 30 days after invoice, but if the goods have not at that stage arrived in London, then it's not payable, and the condition precedent is to payment. So, my lord, there will be cases, whether your lordship thinks that Tibergian is one or not, there will be cases which are perfectly easily explicable in terms of ordinary waiver principles. This is not one. No waiver, in fact, has ever been argued, and indeed, the very fact that the sellers are putting to the tribunal a case based on deemed waiver shows that it's not a case of waiver, in fact. Now, the court will have seen from, I don't know, from Skeleton and from the way in which they developed the case already yesterday, that they rather expand beyond the deemings in paragraph 29, and we go beyond satisfaction and waiver and into implied term or construction of the contract. Now, there isn't necessarily any harm in writing reference to construction or implied term into paragraph 29, provided that one bears in mind that it will be a deemed implied term and a deemed construction too. Because if it's possible to establish a term implied in facts on the facts of a particular case, then again, you can decide the case on perfectly orthodox principles. You don't need resort to general principle.
Unless the general principle is itself the principle of presumptive construction, which is maybe one view of what was being said in Newmont.
That is what it would amount to, my lord. And that's much the same thing as saying it's a deemed construction or a deemed implied term. Whichever way you look at it, it is not based upon saying, and again, the case has never been put, it is possible by reference to particular factual matrix of this particular case to imply a term in fact. Nor has it been put that it is possible by reference to particular factual matrix of this case to take a wooden capita analysis which points to a particular construction of this particular contract. Now, my learned friend did yesterday propose some wording which he suggested might be put into clause 2, either as a matter of construction or as a matter of implied term, along the lines of unless unlawfully prevented. But that's not based upon anything in the factual matrix of this case. He would propose that similar or equivalent wording would be imposed, implied, or read into any situation where the performance of the condition precedent to accrual of the debt has to be performed by the debtor, or the debtor at least has to do something in order to enable the condition to be satisfied. It is...
Well, I don't think he does, you see, because he accepts that Collier and Hayward is good law for what happens in the circumstances of an FOB sale contract. So he doesn't say it would apply in every case.
My lord, he then makes a carve out for the cases in which it's been said it doesn't apply. Yes, yeah. In order to reconcile his proposition with the variety of cases in which it's been said it doesn't apply.
So it is. It is a fact-specific submission.
It's fact-specific in the only in this sense that allegedly it applies to some sort of contracts and not other sorts of contracts. But beyond that, it's not a question of the factual matrix of any particular contract. It is, as your lordship says, it's a presumptive principle of construction. It's what it amounts to. What it amounts to is a rule of law, really. I mean, in a sense, once one realizes that whether you talk about satisfaction, waiver, implied term, estoppel, quasi-estoppel, once you realize that you're not really talking about something confined to the specific case, you're not talking about these things in reality, you're talking about dealing. You can almost express the proposition by not referring to waiver, fulfillment, quasi-estoppel, or anything else. You can just express it as a proposition of law.
Well, is that right? If it's a question of contractual intention, and this is a principle which is presumptive, then where it applies, the mechanism by which you give effect to it, whether you say it's equivalent to performance or you're absolved from the necessity of proving compliance with the condition, or it's in effect a waiver, or it's a quasi-estoppel, those are not juridical concepts which determine how you get to the result. They simply are different ways of expressing the result, which, if it's a principle of construction, is presumptively the result at which the parties intended to arrive. So that one's not looking at those juridical concepts as the foundation for the principle. They are simply different ways of expressing in different language what the effect of the principle is.
Well, that's the point. You don't say, well, it's waiver, and therefore we look at the facts of the case and say, oh, are there elements of waiver laid out? You don't begin with the concept and work your three. They're ways, juridical ways of expressing a conclusion, but you don't need them. You don't need them. You can just express the conclusion. In substance, the reference to waiver.
Well, you've got to express the conclusion in some way. You can express it as deeming that the condition is fulfilled. You can express it as deeming fulfillment of the condition as dispensed with, as waived. And then if one's looking at it from, let's say, a pleading point of view, you can say you're absolved from the necessity by way of reply rather than by way of your statement of claim for saying that the condition has been fulfilled. These are all matters of language which don't really matter.
They don't.
If the principle is that's the result the parties are deemed to have intended to have arrived at by a presumptive process of construction rather than by some absolute rule of law.
My lord, your lordship has the point. They're not necessary. And in a sense, they're redundant. They just clutter up. What the other side are really in substance contending for is some proposition of law, whether presumptive or conclusive, however it comes to. And what they would like the court to decide, the substance of it is this: that if a debtor's breach of contract prevents the satisfaction of a condition precedent to the accrual of a debt, then the debt accrues unconditionally. That's what they want. Expressing it in terms of waiver, deemed satisfaction, there's not necessarily any harm in it, but it's not necessary. Of course, since these things are all deemed, they're just ways of stating the conclusion. And the ultimate proposition is that.
Can you state that proposition again?
Where a condition, sorry, free moment.
This is your formulation of the case against you. Where a condition,
Where the debtor's breach of contract prevents the satisfaction of a condition precedent to the accrual of a debt, then the debt accrues unconditionally. That's what it amounts to. As I said to the court yesterday, what it amounts to is this: if there is an express condition precedent to the accrual of a debt, then the seller's case is if it's satisfied in fact, then the debt becomes unconditional. If it's not satisfied in fact because of the debtor's breach, then the debt becomes unconditional. As soon as you've got a breach, you in effect write the condition precedent out of the contract. That's what it amounts to. When you look beyond deeming this, deeming that, and the other, that's the substance of it. And that is, it subverts what the contract actually says. Quite plainly, I made this point yesterday. But if the contract says that there's a condition precedent, then there's a condition precedent. You're not giving effect to the meaning and wording and meaning of the contract if you just write the condition precedent out by saying, well, it doesn't matter whether it's been satisfied or not, because either way, the debt accrues. And it is contrary, in my submission, to principle, it's contrary to authority, and it's not supported, contrary to what my learned friend said yesterday, by any countervailing authority in its favour. Now, in our skeleton, we've gone into principles at paragraphs 33 to 44 in the bundle at page 128 and following. We've identified 9 points of principle. They broadly correspond to the judge's analysis at paragraphs 25 to 29, page 23 to 26 of the bundle. And because we've gone into them in some detail in the skeleton, I'm proposing to concentrate on authority. I'll allow us perhaps say something more about the principles, but for the moment, just to rest with what we've said in skeletal principles. Now, authorities. Contrary to authority, the first case I'm going to mention, I mentioned it yesterday, is Luxor and Cooper. I don't want to go back through the detail, but just to recap, if the general principle is right, then the pleaded case in Luxor and Cooper is bang within it. Because the agent has done all that he is required to do. He has introduced fire.
I think you mean the unpleaded case.
The pleaded case, the pleaded facts, the pleaded facts.
No, the pleaded case was a claim in damages.
The pleaded case is a
What
claim.
you mean is the facts would have supported an unpleaded case for the price.
If the facts have been as they were pleaded, because the House Law said there wasn't any breach at all. But if the facts have been as pleaded,
Facts is pleaded,
The
but a different cause of action asserted.
if the facts had been as pleaded, that is to say, the agent had done all he could by introducing a willing buyer, and the only reason the commission had not been earned in terms was that the vendor in breach of contract had refused to complete. If that had been the situation, then that would have been foursquare within the general principle.
Yes, but Houselord said that the vendor wasn't in breach of contract because by engaging an estate agent on these terms, you don't commit yourself to accepting any purchase.
Indeed. And so,
So there was no breach of contract. Therefore, the principle didn't apply. So I don't see how you can. I don't see how Luxor and Cooper establishes the contrary to the proposition you're facing.
what you get out of in my submission, my lord, is this. That was the case that was being put. Now, the agent did not think to say, and if I'm right about it, then on the basis of Mackay and Dick or anything else, I'm entitled to claim in debt.
But it made no difference to the agent
And-
because he claimed in damages the amount of a debt.
That is
And on the
also true.
basis of Court of Appeal authority, he would have succeeded on that if he'd established the breach.
It's true that there was a point that the damages would be the same as the debt, but it's also, as I showed your lordships in the passage here yesterday, there's no hint in anything said by the lords in Luxor and Cooper that the facts as pleaded would have given rise to a claim for debt, and indeed the lordships all took it as axiomatic that there wasn't a claim in debt because the condition had not been satisfied. And none of them suggested that if there had been a breach as pleaded, that would have turned the situation on its head and turned it into a debt claim. There's just no, doesn't occur to anybody in Luxor and Cooper to think that the presence of a breach gives you a claim in debt.
But it's quite conventional for courts to decide cases on the basis on which they've been pleaded. It was a claim in damages. It wasn't a claim in debt.
Well, my lord, I see that, but on the other hand, you see that all of their lordships went out of their way to explain why there wasn't a claim in debt, and they said it's just because they could just have said the only claim that's been pleaded is damages and dealt with on that basis. But all of them went out of their way to say why there was not a claim in debt, and they agreed that there wasn't a claim in debt. And all of them put it in terms that there wasn't a claim in debt because the condition precedent hadn't been satisfied.
I don't think they used the term condition precedent. This is a point I mentioned yesterday, and it's troubling me a little bit. It may not go anywhere. Under the RSC, there was a provision which said the plaintiff doesn't need to put in the statement of claim that conditions precedent have been fulfilled. But the plaintiff plainly does need to plead the things which entitle him to payment of his debt, goods sold and delivered, or in the estate agent's case, I introduced a purchaser who purchased, do need to be pleaded, because that's... So there is a distinction drawn, there was a distinction drawn, I don't think it's there in the CPR, but in the RSC there's a distinction drawn between what the plaintiff needs to plead as part of his cause of action, which generates the entitlement for debt, and conditions precedent, strictly so called, which are a matter for defence. And then it's for the defendant to plead, this was subject to a condition precedent and it wasn't fulfilled, at which point the plaintiff replies, you can't take that point because it's your fault, it wasn't complied with. So I don't think you'll find in Luxor and Cooper any of their lordships referring to the requirement before the commission is payable that the purchaser purchases the property as a condition precedent of that sort. It's something which needs to be done before the commission becomes due, but I'm unhappy about describing it as a condition precedent in that sense. Does that, I don't know if that's a slightly rambling question.
No,
Sorry.
my lord, it's not. I mean, I would suggest it's a little bit unsatisfactory, perhaps, to approach the question of law with too much focus on what old pleading rules might have been. It's one of the difficulties one gets with a case like Hotham, where it's all about old pleading rules rather than substance. If one looks at it as a matter of substance, the debt, the commission, is not earned
Yes.
until something is done, that being the completion of a sale. Perfectly natural matter of terminology to say that that is a condition which has to be satisfied before the debt is earned.
Well, I understand that. I'm not sure that that's the language used by their lordships. Anyway,
There are
I've made the
conditions-
point. But
there are
it is.
conditions precedent and there are conditions precedent. Sometimes they're promissory conditions which have to be satisfied by the prospective creditor.
Well, underlying the point is whether if the principle regarding the sellers are putting forward, it relates to conditions precedent. The question is whether Luxor helps you at all, because is it a condition precedent so called?
I understand that, but
just
I
in
would
the
say that-
same way as the provision of goods in exchange for payment, you wouldn't naturally describe that as a condition precedent. But there isn't, say, the same point being made
In the sale of goods, it's a condition precedent which you have to perform yourself because you've got to transfer.
but no one uses that term.
Payment of the price and
Or provision of the contract rather than a condition precedent to.
payment of the price and delivery are described in the Sale of Goods Act as concurrent conditions. They are conditions.
Yes, but that's a different.
But I do submit that if you look at a substance on that, the facts in Luxor is that it is something which has got to be satisfied before the conditions. And it didn't occur to anybody in Luxor to think that, well, if the reason that it's not been satisfied is a breach, involves us into a debt claim. Now, the next case is Colley and Overseas, which my learned friend told you a little bit about yesterday. This is in the authorities bundle at tab 7, page 91. This is the FOB sale case. On normal principles, property would pass and the price would be earned when the seller puts the goods on board the buyer's ship. And Mr. Justice McCarty noted that at page 96. And the buyers repeatedly failed to make an effective nomination, so it became impossible for the sellers to put the goods on board the buyer's ship. And so property did not pass. And the case which was put by the sellers was that none of that mattered because they were entitled to proceed on the basis that property was deemed to have been passed, relying upon Mackay and Dick. And the court will see just after the head note how they argued it. At the bottom of page 91, the defendants by their default, etc., etc. The principle of political was that which is stated in the head note to Mackay and Dick. The seller was treated as if the test had been satisfied, so here the plaintiff must be treated as if the goods have been put on board. By conduct precludes him from alleging that the property has not passed. And at page 96, roundabout in the middle, Mr. Justice McCarty says that if you accept that principle, and indeed if you take the head notes of Mackay and Dick at face value, then the results would be far-reaching and extraordinary. He then discusses the facts of Mackay and Dick. I just ask you to note, the court to note, if you go back to page 94, this is in the context of my learned friend's, what he says is a qualification for the general principle, like you've got to do all you have to do. At 94, by the first hole punch, Mr. Justice McCarty says that the plaintiff on his part did all that he could carry out his obligations, and nothing more that the seller could have done. And if the court goes back to 96, the second hole punch, the judge discusses the facts in Mackay and Dick. And at the bottom, going over to 97, it says that a specific machine was fully delivered and apparently the property in the machine actually passed. And he says it's true that the Scottish law decision, but he then, having just considered some Scottish authorities, says that by about the first hole punch, that it passed under Scottish law as well. So his conclusion around in the middle is that the sale and delivery in Mackay and Dick must be deemed to be complete. Payment of the price was therefore subject only to a resolutive condition imposed by the test clause. Resolutive condition being a condition defeasant. Now that, as we set out in our skeleton argument, that reflects, we will submit accurately, Lord Blackburn's ratio in Mackay and Dick, that there is a sale and delivery subject to condition defeasant. and the effect of that with property passing is that the price is earned, and as Mr. Justice McCarty says here, the condition attaches to payment of the price because the price is earned when the property is passed. Now, in Colley's case, property had not passed, and so the price had not been earned. And so Mr. Justice McCarty says between the two hole punches that the actual decision in Mackay and Dick isn't in point and it can't assist the sellers. The real question is not so much applying the facts in Mackay and Dick. The real question, he says, is to the extent to which the principle indicated by Lord Blackman in the second passage operates to make a price payable which, apart from that principle, would not be payable. He then comments upon the fact that Mackay and Dick is cited in English textbooks as well as Scottish ones, and he then gives some examples. He doesn't say what Addison and Leake say, he does quote from Chitty, who put the matter very broadly thus. And I just ask the court to note that the way it's expressed in Chitty is a contract of sale payment is conditional. Payment, not earning of the price. And that mode of expression is consistent with what Mr. Justice McCarty has said about Mackay being a case where property passed, the price is earned, and the condition attaches only to payability of property earned. So that quote from Chitty is consistent. Then he says, so too in Benjamin there's this passage. And then Benjamin quotes from Hotham and East India, which is referred to in Panamida, and which my learned friends rely upon. And I do submit that the linking language which Mr. Justice McCarty uses to get from Chitty to Benjamin, so too, suggests that he regards Benjamin and Hotham as all of a piece with Chitty, and indeed all of a piece with Mackay and Dick, as talking about a situation in which, in Mackay and Dick, the price has accrued but is not payable. Hotham, of course, is not about price and debt, it's about damages. But it was suggested that he sees it as all of a piece and as being a situation where the right is accrued, but payment is being deferred. And in my submission, that is the correct reading of Hotham. I'll come back to that. And Mr. Justice McCarty, in his discussion of Mackay and Dick, in his citation from the textbooks, is distinguishing the case where the debt, the price, has been earned, but there may be a condition on payability, from the case where it has not been earned, and that becomes clear, very clear and explicit, at page 99. Round about the second hole punch. In my opinion, subject to what I say here after as a stall, I'll come back to that. No action will lie for the price until the property has passed, except in a section 49(2) case where the price is payable on a set date, property or no property. A clear distinction exists between cases where the default of the buyer has occurred after the property has passed and cases where that default has been before the property has passed. To the former cases, Mackay and Dick may be applied on appropriate facts. To the latter case, Mackay and Dick does not apply so as to enable the buyer to recover the price as distinguished from damages for breach of contract. Now that's said specifically in the context of a sale because it's a sale case, but in my submission it can be broadened. Where the significance of the passing of property is that the price is earned. The principle is that where the debt has been earned, the debt has accrued, then the principle of Mackay and Dick may, or appropriate facts, be applicable. One doesn't necessarily have to put it in Mackay and Dick terms. A case like the Karen Vatis simply puts it in terms of breakdown in the machinery of payment. And as I said yesterday, it doesn't actually make it dependent upon breach by the debtor, where the debt has accrued. But if the debt has not accrued, Mackay and Dick does not apply to enable the creditor to recover the debt, as opposed to bringing a claim for damages. hold that Mackay and Dick applies where property is not passed will lead to extraordinary results. Indeed, he says it would mean that in every case where the seller had tendered delivery, they would be entitled to say that they were deemed to have passed property and they're entitled to sue for the price. He then says at 311, down by the second hole punch, the same is true of sales of land. You don't have an action for the price unless it's been earned. Now, he refers there to a stopper. I just asked the court to notice he comes back to that at page 312, about a dozen lines from the end, and what he says there is that there is no estoppel on the facts and documents, none of the elements of estoppel are here present. He is clearly talking there about estoppel on the facts, estoppel in fact according to normal principles. He is not saying that some sort of deemed estoppel may be an alternative to deemed satisfaction of the condition. And there was no estoppel on the facts of the case. Now, that's a first instance decision. It's not binding on this court, of course, but I do submit that it's a very clearly reasoned analysis. And I submit it's also a correct analysis of Mackay and Dick. I'll come back to that. And it's a clear recognition, and in my submission, a principal recognition, that if there is a failure of condition precedent to payment of an accrued debt, that doesn't mean that the price is never payable. But if the condition precedent is to the accrual of the debt, that doesn't mean that the debt is treated as accrued, even if the failure is due to the breach by the debtor, as it was. Then the other cases, the first is Little and Courage, which my learned friend told you a little about yesterday. That is in the bundle at 19,314. Now, this is the case about renewal of a lease of a pub, where the tenant was entitled to a new lease subject to various conditions. One of which the tenant agreed a new business plan. And what happened was that because the landlord had been advised that there'd be legal difficulties if it renewed the lease, it decided it wasn't going to renew the lease, and it simply did not take any initiative in relation to a new business plan. And no new business plan was agreed. And the landlord said the condition precedent has not been satisfied, you're not entitled to a new lease. The tenant brought an action for specific performance of the obligation to provide a new lease. And it argued on various bases from 320 onwards that there was an implied term of one sort or another, and the landlord was in breach of it. And the Court of Appeal rejected every term which was said to be implied, broadly on the same basis that it was a case of a unilateral contract and you couldn't apply an obligation to a unilateral contract. So the case that was put that there was a breach failed. And in discussing some general principles at 319, Justice Millett stated a number of general principles. The significant ones for present purposes are probably the first three, but I rely in particular on the first one. The point there in the first one is that Lord Watson in the time expresses a doctrine of deemed fulfilment or waiver as a doctrine of civil law, that is to say of Scottish law at the right time. And Lord Justice Millett says here quite clearly that that is not English law. And he says that in in going on to 2 and 3, that in English law the question is of construction, whether the condition precedent as a matter of construction has been satisfied, and if not, whether in the circumstances it needs to be satisfied, the process of construction includes the maximum that necessary implication of unexpressed terms. Now that's, in my submission, that's clearly talking about terms implied in fact. Necessary is the test for terms of fact. And then the maxim about not taking advantage of a very wrong, which is the maxim in Althusser, which I'll come back to. And he then says that that doctrine may, he says, lead to the conclusion that a party is precluded from claiming the condition has not been fulfilled, but nothing less than a breach will do, and he refers to shield. He says may. He's not setting down any binding universal proposition there. Now, obviously what my learned friend says about one in particular is, well, all that Lord Justice Millett is saying is that, or Lord Justice Millett can be understood as saying, that the general principle exists, but it's not a question of deeming fulfillment or deeming waiver. It's about construction. To be some, as Lord Popplewell says, some presumptive rule of construction which applies in the principle of law. In my submission, that's not what he's saying, and that becomes clear when he applies his construction thinking to this case, which he does at 323 to 324. The conclusion of construction which is come to in this case is in substance this, that because the business plan is there for the benefit of the landlord, it doesn't make any sense to say that the obligation to agree a business plan attaches and has to be complied with even if the landlord isn't bothered and doesn't present a business plan for discussion. And therefore, as a matter of construction, the condition is subject to an implied qualification, which he states at 324, pretty much in the middle. The lessee shall, if so required. But Lord Justice Millett doesn't arrive at that conclusion by applying any interpretations of Mackay and Dick or any version of the general principle. He reaches it as a perfectly orthodox matter of the construction of the particular contract before him, in the factual matrix of the particular case before him. It's not based on presumptive principles of law, deemed waiver, deemed satisfaction, deemed quasi-estoppel, deemed anything. It's
That's because, as you said earlier, Justice Millett approaches this on the basis, which we know to be the case, that the principle that is relied on in Mackay and Dick is you can't take advantage of your own wrong, and you need a breach of contract in order to engage the principle. I know you say, Karen Vartis, there are other circumstances in which one can get payment, but certainly the principle which we see in the cases is premised on a breach of contract by the paying party. And because an option is a unilateral contract, there's no obligation on the landlord to do anything, so you can't imply an obligation into that, and therefore there's no breach of obligation by the landlord. Hence, the entire application of the principle is just out of the window. That's why he has to find, why he does find, an alternative basis for giving the tenant relief, which is the one that you've pointed to, which is that you construe the requirement to agree the business plan as something which it's up to the landlord to say that he wants. If he doesn't say he wants it, you don't have to comply with it. But that's not rejecting the principle. It's saying the principle doesn't apply on these facts.
With respect, he makes two separate points, I would submit, 319, my lord, in 1, 2 and 3. Firstly, he plainly does, in 1, reject the civil law deemed fulfilment principle, which is Lord Watson in Mackay and Dick. He does say that the principle that the maxim that you cannot take advantage of your own wrong is not applicable on the facts, because that depends on the breach as per Cheel, and there's no breach. I'm going to come on to the Algersame principle. But he's differentiating two things. And when it comes to the civil law concept of deemed fulfilment, he's not simply saying it doesn't apply on the facts, he's saying quite clearly it's not English law.
No, but what he says is English law is if in breach of a contractual obligation a party is prevented of fulfilment from additional precedent, he may not only be liable in damages, but may, and I accept he just says may, he doesn't need to go into more than that, be precluded, that's the same language as estoppel or quasi-estoppel or whatever, from claiming that the condition has not been fulfilled. Now, the discussion you had with my Lord Justice Popplewell earlier this morning was to the effect that it really doesn't matter whether you label it fictional or deemed fulfilment, or whether you label it as being stopped or precluded from claiming it's been fulfilled. The practical effect is the same. You can't rely on it. Now, why does it matter whether it's called fictional fulfilment or not?
Because what the Lord Justice Millett is speaking about in 3 is the maxim that a party may not rely on its own wrong, and he cites Cheel.
Yeah.
As I said to the court yesterday, and as Lord Bishop said in Cheel, one has to be careful with the broadness of the expression, because the Cheel case is the classic application of that maxim, where one party says that the other party is not entitled to rely upon a clause terminating the contract if the relevant events have been brought about by their own breach. Cheel was another case where it was held that they hadn't been brought about by their own breach because there was no breach of contract, like here. So the maximum didn't apply in Cheel, the maximum didn't apply here, but that is the principle which lurks behind that maxim. I don't take any issue with that principle. It's been clearly established repeatedly by the House of Lords. But that's not what this case is about. We're not concerned with the Algersame principle. This is not a case in which one party is relying on its own breach to say that a termination clause has been triggered, or that any other clause entitling it to take a benefit under the contract has been triggered. As I said to your lordships with respect yesterday, this is an area of law which is punctuated by broad statements, sweeping statements, which go beyond what is required by the context, and if one takes them and tries to apply them in other circumstances, they are apt to mislead. We said in our skeleton, there is no abstract principle of law that a party may not be entitled to derive a benefit from its own breach of contract. And if there was, then the entirety of the law of remedies in English law would have to be rewritten, because you would have to make disgorgement and account of profits an absolutely routine remedy in any case where the party in breach was better off by breaking the contract than they would have been by performing it, or restitutionary damages, or other remedies which are designed deliberately and consciously to strip the parties of benefits. Now, they are not routine, they are exceptional. They've been repeatedly said to be exceptional. The approach of the remedies in English law to breach of contract, setting aside specific performance, which seeks to specifically enforce the contract in specie, which is comparatively rare. The approach beyond that, setting aside exceptional cases of disgorgement like Attorney General Blake, is rooted firmly in the overriding compensation principle. And the compensation principle is calculated to compensate the victim for losses sustained, not to deprive the contract breaker of benefits acquired. And if you can break your contract and compensate the claimant for any damages that they have sustained and still be in profit because you found someone who's prepared to pay a lot more, much higher than the market price for the goods because they're desperately short of goods, then good for you. That's the attitude that English law takes. That is what the American jurisprudence called the efficient breach. The American jurisprudence would say that that is something which must be encouraged in any sensible capitalist economy because it promotes efficiency and it makes sure that the people who are prepared to pay the most for the commodity get the commodity, and that's the way the market should work. Now, English law does not go so far as to say that it actively promotes that, but it certainly tolerates it, it permits it. It's inbuilt into the structure of the law of remedies, that providing you compensate, you can take the benefit of breaking your contract. And it doesn't matter that your breach of contract was deliberate. I mean, in most cases, certainly a deliberate breach, the very reason why the breach takes place will be that the party breaking has worked out that they're going to be better off breaking the contract than performing. English law says that's fine. Now, if there was some general abstract proposition of justice in English law that a party may not benefit from its own breach, English law would not say fine. English law would say restitutionary damages, counter profits. And the proposition, this is the problem in my submission, the proposition is bandied around by my learned friends, a party cannot take advantage of its own breach. It is simply too broad as put at that level of abstraction, and it is not English law. It is, as Lord Diplock said very clearly in Shield, it is broad language for a specific principle of construction. I do not take any issue with that principle of construction, but it's just not applicable. Nothing to do with this case.
Is it your submission that it is only applicable and restricted to cases where a party is seeking to rely on their own wrong in order to obtain a right to terminate, and cases where they're seeking a benefit from the contract? I detected an element of that in your earlier submissions. Did you say that those are the only circumstances in which there's scope for it to apply?
If you look at Al Hussein and the New Zealand shipping case, which we have in the bundle as well, they both go through the old cases. And they go back to Reed and Farr.
Sorry, just before you, I mean, is what I put, is that your case?
They go through the old cases, and the old cases up to Al Hussein are all about termination clauses. You go through.
No, but, sorry, but just before we, I don't want an explanation of why the answer is what you're going to give. I just want to know what the answer is first, and then you can explain it.
The answer is yes.
Yes.
And the reason is that if you go through all the cases up to Al Hussein, they're all about termination clauses. And that was the point that was run in Al Hussein. The argument was put in Al Hussein, this is not a termination clause, therefore this broad maxim has no application. Now, the House of Lords said no, and we don't accept that. It can apply in other circumstances where you are relying upon your own breach to say that some right under the contract has been triggered. Al Hussein, as your lordship will remember, that the contract was an agreement for a building lease. And there was a badly drafted provision that said that if the builder defaults on its obligation to build, then the lease will be executed immediately. Now, plainly what the person as a judge said there was a word missing, he should have said not. But the House of Lords said no, there is a principle, which is the principle in New Zealand shipping, you can't take advantage of your own wrong to invoke a contractual right. It goes beyond termination clauses. It applied in Al Hussein, and the rationale, quite a specific rationale, not deeming anything, is that as a matter of construction and the proposed intention of the parties, it has to be read as at the innocent party's option. So although it literally on the face of it says shall be completed, it is to be read down as shall be completed at the innocent party's option. It's a specific principle. It's implemented in quite a specific way by reading particular words in. And that is what underpins this, or lies behind this very broad maxim that my learned friend bandies around as justifying the general principle that a party may not derive an advantage from its own wrong.
But you do accept, I think, that it applies to a case of an accrued debt where the condition is as to payment.
Well, in a sense, my lord, I don't accept that, because as I said to your lordship yesterday, you look at the cases, when you're concerned with an accrued debt and the conditions to payment, the focus is not on breach or wrong or anything, it's just on has the machinery broken down.
Well, you're going to come to explain Anamina
Yes, I will come to
and
Anamina,
Corey
but-
and so on. But
my lord, I do
I
submit-
thought that you supported the grounds for distinguishing those cases as being that they did apply a principle, whether you call it the Abacha principle or Mackay and Dick or whatever, but only in circumstances where the condition was a condition precedent to the machinery of payment, not to the accrual of the debt.
My lord, that I submit is the law, and as I say, you could call it a Abacha principle or Mackay and Dick principle if you like, I suppose, but the way it's put in the Karen Batis is simply the machinery of payment has broken down. And breach or wrong or seeking to rely upon your own wrong doesn't come into it, and nor would one really expect it to, because the point is the debt's accrued. Parties expect you to be paid it. Then some supervening event, breach or no breach, makes the condition precedent for payment unworkable. Can't deprive you of your right to the money. But the focus is not, in my submission, at all on breach or a principle that you can't take advantage of your own wrong, because that's not part of the principle. It doesn't depend upon wrongdoing.
And
So
Mackay
it's
and Dick,
separate from.
Mackay and Dick, you say, was a case of machinery of payment breaking down.
Forgive me, my lord.
Mackay and Dick, you say, was a case which can be characterised as a case in which the machinery
It
for
could be.
payment had broken down.
It could be. That's one way of looking. It's not Lord Blackburn's way of looking at it. Lord Blackburn's way of looking at it was that there is a sale and delivery and a condition defeasant.
It's not machinery of payment, is it? It's fulfilling a test to see whether the machine is capable of digging at a certain rate and
Well,
filling
you could
wagons
make-
at a certain rate. It's very
Well,
difficult to describe that as machinery of payment.
My lord, you could say the same thing in the Karen Batis, where it says that you've got to pay 6 days after the discharge. I mean, you could say it's not really machinery. It's provision for the circumstances in which the money is to become payable. And if it all falls apart for some reason, then the money becomes payable in any event, as per Karen Batis. Now, if one takes Lord Watson's condition precedent analysis in Mackay and Dick, but one also takes Mr. Justice McCarty's analysis in Collies that the property had passed on delivery. And it's not just Mr. Justice McCarty who says that, that's now the orthodox analysis. I'll come to that. So for the moment, you take the case to be property passes on delivery, and there is a condition precedent to payment of an accrued obligation in price. And then it becomes impossible to perform the test. And one might look at it as being a breakdown in machinery of a payment case, yes. The alternative way of looking at it, and this is really Lord Blackburn's analysis, is that it's a sale and delivery of property parcel subject to condition precedent, defeasant. The condition defeasant is failing a test.
And if there's no test,
There was
then
no
it's not.
test.
There was no test. Therefore, the condition was not fulfilled.
Therefore, the defendant was not able to say.
Therefore,
the
no
condition had been
defeasance.
triggered. They had to pay. Yeah, exactly. Now that's the English law analysis. That's the Lord Blackburn English law analysis of Mackay and Dick, and it's quite orthodox. It goes back to the yearbooks. But one can look at the Lord Watson alternative condition precedent analysis in terms of being a sort of Karen Mattis type of case. Yes.
What is the status of Mackay and Dick in English law, according to you?
Strictly speaking, my lord, it may be of some persuasive authority if there is within it some principle on a point where English law and Scottish law are similar. And I say that particularly in relation to Lord Blackburn's implied obligation, the implied obligation of cooperation, as it's called. Notwithstanding that Mackay and Dick is a Scottish case, that's been wholly embraced within English law. You look it up in any textbook, and they will say that that is English law. But Lord Watson is explicitly deciding the case by specific statement in a Scottish textbook of civil law by reference to Pothier's writings on civil law, which in turn go back to the Roman law. He is not purporting to say anything which has any implications for English law at all. And in my submission, that simply has no weight.
Has it been adopted in any subsequent English cases? But Mr. Justice McCarty thought it was English law. Lord Justice Ricks and Abacha thought it was English law.
Mr.
My
Justice
lord,
Devlin
if you
thought
look
it was English law.
My lord, if you look at Collies, it's noticeable that my lord, Mr. Justice McCarty, only refers to Lord Blackman's speech. There's no reference to Lord Watson at all.
Yes, but he says the principle in the kind is he thinks it's a good principle of English law, doesn't he?
Yes, but he's talking there about Lord Blackman's principles, notwithstanding that it's a Scottish case, and that's the point I just made, the principle of implied duty of cooperation. He nowhere refers to Lord Watson at all. And that, in my submission, is no doubt because he appreciates that Lord Watson is not claiming to make any statement of English law. Not a single reference to Lord Watson.
What about Lord Donaldson in the Panamina?
Going to come to the Corey case, my lord, and Panama.
Sorry, in the Corey case.
I'm conscious of time, but I'm going to get there. Now, my lord, that arose out of what I was saying about the Courage and Little case. The other case that I wanted to refer to before I come to my learned friends' cases is the Thompson Astor case. Mr. Justice Scott at tab 15, page 203. The facts of this case were that Asda operated an employee benefits scheme which entitled employees to take up share options. And employees encompass not only employees of Asda, but employees of Asda subsidiaries. And Mr. Thompson was employed by a company which at the time was a subsidiary of Asda and subscribed for some share options. Then Asda sold the company, and under the rules of the scheme, he lost the right to take up his options. So he lost the benefits. And if you look over to page 204, about by the first hole punch, you can see that the claim that he brought was that by selling the subsidiary so that he ceased to be an employee, the defendant had wrongfully repudiated the rules and could not rely on its own acts to complete the options it had run. It's another case where the argument is primarily about, well, was there any relevant implied term that they were in breach of? And the conclusion in the first paragraph in the head note was that there was no relevant implied term and there was no breach, and therefore the repudiation case just could not get off the ground. The second paragraph encapsulates the point which I was going to draw to your ladyship's attention. Mr. Justice Scott says that there was no general principle and that the law in England proceeds by way of implied terms, and the contract took effect as it stood unless a term could be implied that a particular act was a breach.
But what he says is there was no general principle that a party could not take advantage of its own acts unless the party so acting was in breach of a duty owed to the other party.
Yes.
And that's the determinative point in the case, that he finds that there was no
none. That's right, my lord.
obligation.
What he says specifically, 228, by the second hole punch, is that Lord Watson and Mackay and Dick is not English law.
228.
228F, my lord, about 3/4 of the way down. And you'll see the way he puts it is that the ideas of fictional fulfilment or non-fulfilment are not part of English law. The English law of contracts proceeds by implied terms, and in my submission he's not talking about deemed implied terms there. One sees that from his decision in this case. He considers very carefully whether any of the terms alleged are to be implied on the facts of the case, and he decides not. So it proceeds by implied terms. If there is no implied term, then contract takes effect. If there is an implied term, then the doing of the act will be a breach of contract. What he doesn't say is that if there is an implied term, then the doing of the act will make a debt, which is otherwise conditional, accrue unconditional. It's a perfectly orthodox approach that if there's a breach of an implied term, you'll have a claim to breach of contract, and that will be damages, as in the Luxor case. As we accept quite frequently that there'll be a claim for breach of damages in this case. We just say that the damages will be nil, which is why the sellers would like to sue us in debt instead. If they'd like to keep the ships which were worth more than the market value and have a few £1 million as well, please. We say no, that's not the law, they can sue us for damages, but if their damages are nil, then contrary to the complaints that there is no failure of justice like that, or outrageous behaviour which the court needs to do something about. If a party does not suffer any loss by reason of a breach of contract so that its damages are nil or nominal, then it will have received the satisfaction which the law deems appropriate, and there's no reason to conjure some other remedy. And what Mr. Justice Scott says here is entirely consistent with that. You proceed by implied terms. If there's a relevant implied term, you'll have an action for breach of contract, that will sound in damages. You don't proceed along Lord Watson's lines of treating conditions fulfilled so that a debt becomes unconditional and becomes payable as a debt. And again, when he's talking about the approach being contract, he's not saying it's deemed contract or deemed implied term instead of deemed fulfillment. He's not just dressing up the same concept in other language. He's talking about genuine implied terms according to Lord Watson. Now, my Lord, I come to the materials which are relied upon. Actually, just let me say the other materials which I rely upon against the case which is put against. I also rely upon textbooks. And I've referred to them in the skeleton, but let me just tell your Lordship. Your Lordship was taken yesterday by my learned friend to Chitty and Tritle in the bundle at 451 and 581. And they both object in principle to the Lord Watson approach in Mackay and Dick because they say that it proceeds on the basis, in effect, that the machine would have passed the test, and in fact it might not have passed the test. And that's the sort of contingency which can be taken into account if the remedy were damages. But it can't be if you simply have a claim in debt, and that cuts across the damages rules. And our learned friend Peer suggests yesterday that's a misreading of Mackay and Dick. And that all that Lord Watson was saying in Mackay and Dick was the test was deemed to have been performed, but it would somehow in principle have been open to the buyer to plead and prove that if the test had really been performed, it would have been failed, and therefore to say the debt was not due. Now, in my submission, that just does not fit with the expression by Lord Watson of his principle in the speech. There's a single compound condition. The machine must pass a specified test. And Lord Watson's ratio is that that is deemed to be satisfied. And that includes not just having the test, but passing the test. Whether or not the machine would in fact have passed becomes just completely irrelevant once you deem the condition satisfied. That is clearly how it's been understood by Tritle and Chitty. And in my submission, that is the clear and obvious reading of what Lord Watson actually says. And the objection which is made by Chitty and Triton is therefore a good objection. And the nature of the objection is such that it would be exactly the same if you were to say to Triton and Chitty, well, the principle isn't really deemed fulfillment, it's deemed waiver, or it's deemed implied term, or it's deemed quasi-estoppel, or anything else. the objection, however you put it, is that it cuts across normal damages principles. I also
I understand that in Mackay and Dick, because there's a very real question whether the Navi actually worked or not. When it was previously tested, it failed miserably, and it didn't succeed when it was put to the test at the correct place. So, and we saw that as you showed us yesterday, the Court of Session was a bit unhappy about it. So I understand all that. I don't understand how it applies in your case. Under this contract, you had to pay a 10% deposit. Obviously, you've got to open an account before you can pay it into the account. And obviously, and the contract says so expressly, you have to do what's necessary to open the account. How can it be said that there's anything punitive in making you pay the deposit? I don't understand that at all.
Because, my lord, because of, and this is, as we said yesterday, this is why we're having this argument, because of our golden victory.
Yes, but the whole point of a deposit is that the vendor keeps it, it gets forfeited, and the purchaser repudiates the contract or doesn't complete, or all sorts of other things on which it becomes payable to the vendor, without having to prove any loss. That's the purpose of a deposit. It's to be a liquidated sum forfeited to the vendor, and it's a powerful incentive to purchasers to actually complete contracts and not sign up to contracts for the sale of land or contracts for the purchase of ships unless they're actually going to go through with them. And that's how the law works. You get your 10% and you keep it, and it doesn't matter if you haven't suffered any loss on market. You don't have to prove any loss. You get your money because that's what the deposit's there for. And I don't understand why there's anything wrong with that. That is the policy of the law. People who pay deposits lose them if they don't complete.
My lord, that is right. Your lordship puts it absolutely rightly.
So what is punitive in this case about saying you were meant to pay a deposit, you chose not to, you now have to pay it?
Because, my lord, the deposit is security. And what is security is the deposit which has been lodged with the stakeholder.
So if you manage to avoid lodging it, you don't have to pay it?
Right. If the security doesn't exist, it can't be forfeited.
That's not what the Griffin says.
I know the Griffin doesn't say that, my lord, but the Griffin is not about preconditions to payment. The Griffin.
No, I understand that. The Griffin says if you have to pay a deposit and you don't pay it, and as a result, under clause 13 of the then form, the vendor cancels the contract, you still have to pay it.
The Griffin extends the proposition. On the face of the contract, the security is the deposit as lodged. Until it's lodged, the deposit doesn't exist and it's not there as security. The Griffin extends that back a little by saying it becomes security as soon as it becomes payable.
Yes.
In our case, it did not become payable. That's our whole point, because of the conditions.
So because you prevented it becoming payable by your own breach of contract, you don't have to pay it?
Because it did not become payable, even on the extended Griffin reading, it doesn't become forfeit. It's not security. Not security. What is security is the deposit. It's not some notional unaccrued debt. It's the deposit which has been lodged in accordance with the contract, all as extended by the Griffin, which has become payable. And your lordship is effectively complaining that on our interpretation we have a sort of a locus to withdraw and to pay the regular remedy in damages. And
Yes,
that is our case. We say that's right.
Where I'm coming from is this is not a damages claim at all. So it's got nothing to do with compensation, and so there's nothing punitive about somebody losing a deposit. That's what happens.
Well,
and your point, I understand this. Your point is, well, that only happens if you actually pay it and then you lose it. If you can manage to get into a situation where you haven't paid it, you don't lose it. Well, just querying whether that's correctly described as punitive. So even if what Tritle says in the textbooks has some merit, I don't see that it really bites in your case.
It does bite, my lord, in this way. What we say is that we failed to comply with the clause 2 conditions, and that was a breach of contract. The tribunals found that. We said it wasn't, the tribunals found it. So, okay. There can be a claim in damages. We accept that. And if the position was that if we had paid the deposit, if the deposit had been lodged, if we performed, the deposit had been lodged, the deposit would have become forfeit, then there's a damages claim there for the value of the deposit. What we say on the facts here, and this is our golden victory point, is that if we'd lodged the deposit, then it wouldn't have become forfeit, it would eventually have come back to us.
Because of the clause 21.
Because of clause 21, that's the golden victory point. And so we say that there is no claim for damages caused by our breach of contract. And that is precisely why the other side want to get hold of the deposit.
Yes.
We say there is, turning it round perhaps the other way, there's no injustice, there's nothing wrong, there's nothing contrary to principle in saying that they don't get hold of the deposit when the circumstances which make it payable have not accrued, because that's just what the contract says. Now, that does mean, your lordship's right, that does mean that there is a period of time in which we can say that we're not going to perform the contract. Our only liability is damages, because the deposit's not forfeit, because the deposit's not become due, and it does not stand as security. But that's what the contract says. There's nothing wrong with that. And that may not be surprising, because there comes a point at which, if we're going to go ahead, we've got to lodge the security, and it's there, and it's going to be forfeit if we don't perform. And the sellers can say, right, we can now begin putting the goods into a deliverable state, getting the ship ready to deliver. We can begin incurring costs, and they're covered. They are protected by the 2 million, and they can safely go ahead. On the other hand, there is a period of time, there's a point of time up to the deposit being lodged, we would submit, or at least becoming due, as the Griffin would say, when the deposit does not stand as security. They are unsecured. And that does give us a locus, before they started in reliance on the deposit getting the ship ready for delivery, it does give us a locus to withdraw and to say we'll pay you damages in the ordinary way because we're in breach. But that is the structure of the contract. That is what it says. It's open to a seller to say, I won't sign the contract unless you pay me the deposit. There will be no gap. I will sign, I will contract upon lodging of the deposit in my bank account and not before. That may be something which some sellers want to do and maybe sense in it if they want to be able to enforce the deposit. It's not this contract. There is nothing wrong with giving effect to this contract according to what it says, according to what the parties agreed. I come back to the point yesterday. Whichever way it is put by my learned friend, what it amounts to is that the contract has to be given effect as, if the condition is satisfied, the debt becomes due. If the condition is not satisfied because of a breach, the debt becomes due. You may as well just ignore the condition. And this is all riding roughshod over the contract the parties made, and it is unprincipled. And
Well, it doesn't dispense with the condition completely, because it may be that there's something that the sellers fail to do, which prevents
it writes
the
it out in
condition.
the case of breach, man, but breach by us, my lord. That's the
Breach
point.
by you,
Breach
exactly
by you,
so.
just writes it out.
Yeah.
Just writes it out.
And one approach might be, I'm sorry to harp back on this, that if the principle we're debating is simply a principle of construction, which applies in some cases and not others, the question is, what did the parties intend in this contract, where the deposit was to be an earnest of performance which would be forfeit? Did the parties intend that this was the kind of case in which a party could not take advantage of their own breach, so that they would be the sellers would be put in the same position as if the deposit had been paid, if that were a breach, which is a question which arises by reference to this particular contract, rather than by some general principle. But speaking for myself, I can see force in your argument that the way that the question of law is framed, as if it's a general principle that applies in all cases, is not the case that's been argued in front of us. It's accepted by Mr. Kenny that if you took that in its full width, then the FOB sale cases.
Yes, well, he has to make the big exception for the cases which are inconsistent with it.
Yeah.
My lord, yes.
But conversely, it is a principle I think, which you say does have some content in some circumstances, at least if it is reformulated to refer to condition precedent to payment as opposed to condition precedent to accrual.
I don't really accept that, my lord. I don't accept that the Karen Battis is an illustration of the general principle. My learned friend says this yesterday. I accept the Abacha principle applies in some cases. I don't accept that. For the reason I've given, the Abacha principle it hinges on breach. The machinery of payment cases, they don't hinge on breach. They're separate principle, really. And in Mackay and Dick, there was a breach, but if you look at it as a machinery of payment case, it's not essential that it was a breach. The point I'm going to come on to, if there's a breach in Panamina, Lord Thankerton doesn't seem to think it's important. Doesn't mention it. If there's a breach in Corey, Lord Donaldson doesn't seem to think it's important. Doesn't mention it. These cases don't rest on breach. I can understand why my learned friend says there was a breach. There may well have been, but that is not critical to the analysis. In either case. They are failure of machinery cases, and that, I admit, is not a version of the Abacha principle, it's something else. So I do not, with respect, accept that the Abacha principle, the general principle, exists in some circumstances. I say it doesn't exist at all. As I said yesterday, there are different rules for accrued debts and for unaccrued debts. They've got nothing to do with the general principle. Coming back to my lord's point, yes, of course, a deposit is always an earnest of performance and security, but the parties are entitled to provide in their contract when it will become security. And they have done in this case. Now, as I said, if a seller wants to be absolutely copper bottom from the beginning, they'll say, I'm not going to sign until I get the security. That's a point that's made by Lord Justice Gough in the Blankenstein. I won't ask you to look it up now. But that's the point that Lord Justice Gough makes. He says, maybe the seller will now be thinking to themselves, I should have asked for the security in my bank before I signed, but that's not the contract they made.
It is a dissenting judgment.
It is a dissenting judgment. That doesn't mean it's not right, my lord, on that point. He dissents on what's the measure of damages. That's the reason I've not taken your lordship to it, because there are things in there which I would submit are illuminating, but I knew that somebody would say to me it's a dissenting judgment. I'm not going to take your lordship to it, but he dissents on the point of the quantum of damages. What he says about this point in my submission, it's just obviously right. He's open to the parties to decide for themselves when and under what conditions the security exists. Not just in shipbuilding contracts, but any contract. Any contract where there's to be security, a guarantee or anything else. And when it doesn't exist until it exists. And if it's down to a breach by the debtor or the obligor that it doesn't exist, then you can sue them for damages and you can terminate the contract for repudiation in all probability, as happened here. You can get damages for the repudiation if you suffered any, but they haven't because the ships were worth more than the market. But what you don't get is to get your hands on the security when it hasn't become security, because the conditions for it becoming security have not been satisfied. And even on the extended Griffon analysis, it doesn't become security until it becomes payable. And it never did. And that simply reflects the contract that the parties made. And the court should give effect to the contract that the parties made and not subvert it. That is not an unjust or astonishing proposition. It does not contravene some fundamental principle of English law that a party cannot take advantage of its own wrong. There is no such principle. I've been through that. We are not arguing for some extravagant proposition in this case with respect. We ask the court to apply perfectly orthodox principles of the construction of the contract and to give effect to it in accordance to its terms and its meaning, and that is it. In a nutshell, that is our case. I've gone on, we've elaborated at some length, that is our case. Now, textbooks. I've been to Chitty and Triton. I was also going to refer to, your lordships will be familiar with, the ladyship will be familiar with the White and Carter principle. White and Carter says that when there's a repudiation, and you've got the right to accept it or not accept it, you can say I'm not going to accept it, and you can go on and earn the the debt. And you can
As long as you
recover
can perform without the
if you
cooperation
can
of the defendant.
perform without the other party. And it doesn't say that if the other party's failure to perform is a breach of contract, which is going to be, you can earn the debt anyway. Now, if my learned friend is right, then White and Carter is just at odds with his principle. I mean, if the facts of White and Carter had been that the advertising company was going to come on to the client's land to erect the board and then get paid for that, and the client repudiated and said, I'm not going to let you onto land, then if my learned friend is right, the company will be able to say, well, I was unable to get onto land because of your breach of contract, and it's all got to be deemed to have been done, or deemed satisfied, or deemed waiver, or something else, and I've earned the debt anyway. White and Carter is absolutely clear. It's a well-known principle. It's stated in all the textbooks. We've given you courts with references in the bundle. Chitty 489, the Butterworth's contract textbook 518 and 520.
Sorry, just give me those references again.
Sorry, my lord. 489.
Chitty 489.
489 Chitty, and then Holson, as it now is, 518 and 520.
Those are bundle references.
Those are bundle pages, my lord. And then bundle pages, I'll just give you the references again, 593, 595, 413, 415, 490, similar to the White and Carter principle. These are the familiar principles that the seller, the builder, the employer, the carrier, if they don't earn their pay because the other side won't let them do the work, or won't ship a cargo, or won't accept the goods, then the remedy is damages, not debt. Now, my learned friend, of course, he tried to get round those by saying, oh, well, there's a qualification, albeit that it's not mentioned in any of the cases which supposedly establish the principle. There's a qualification that the creditor has to have done all that it has to do to earn. And that explains these rather inconvenient cases, which on their face are completely at odds with the principle. And there are 2 points about that. Firstly, one would have thought, just as Mr. Justice McCarty plainly did in Colonies, that a seller who has tendered the goods and had them wrongfully rejected, or an employee who's turned up to work and been shut out, would be entitled to say, well, I've done everything that I can, done as much as I can, done what I can do. Why, on the general principle, if it applies, should they not have paid? The truth is that the qualification, in fact, is not principle. It's only invented in order to try to explain these cases away. And the second point is that if you accept the qualification, it doesn't save the general principle, it destroys it. And that's my Lord Justice Popplewell's point, because once you accept the qualification, it isn't a general principle at all. It's a principle that applies to some cases and not others. And it's not really very clear how you decide which cases it applies and in which it doesn't. So this is not a saving grace, it's entirely destructive. Now, I've given your lordship those references to textbooks. I'll also ask your lordship just to note Andrew's contractual duties at 406, Carter's breach of contract at 439. Carter's breach of contract, very clear about it. Breach of contract does not make a conditional obligation unconditional. And that's what we say. And what principle could it? Contract says it's conditional, it's conditional. You don't say the contract just doesn't apply just because there's a breach. Now, the authorities which are said to be in favour of the general principle. Since I've just been talking about textbooks, I'll come to the textbooks which are said to support it. It won't take long because there aren't any. Not a single textbook authority has been cited in favour of this proposition. Not one. Now that is very telling. Because Mackay and Dick and Panamina, these are not obscure cases. You can look up any general textbook contract, it will be replete with references to Mackay and Dick. and to Lord Blackburn's, in particular, his proposition of the implied duty of cooperation, which has been embraced wholesale into English law. It's very well known. You won't find anyone citing it for the general principle. The closest you'll get is Triton and Peel, for example, saying that this is what Lord Watson said, but it isn't English law. Palomino, it's not all over general contract textbooks like a rash, but not surprisingly, it does feature quite heavily in specialist building textbooks. Keating and Hudson, quite a lot of references. You will find it referred to in the context of, for example, interpretation of certification clauses, implied terms limiting the scope of certification clauses, the nature and scope of the certifier's function, when the certifier disables him or herself from performing the function, what constitutes collusion, and the home and guppy prevention principle. I'll come on to the home and guppy prevention principle, but you won't find it being put forward for a proposition in as broad and sweeping terms as the sellers would have you accept. Cases. Palomino. Before that, so far as cases broadly go, there isn't, my proposition is there is no authority binding on this court which supports the general proposition. In terms, or indeed which establishes any broad principle that if the accrual of a debt is subject to a condition precedent, the debt accrues unconditionally if the debtor's breach prevents satisfaction of the condition.
Sorry, could you just give me that again? No authority binding on this court.
No authority binding on the court which establishes the general principle in the terms in which it's stated or asserted by the sellers, or which establishes any sort of principle that if the accrual of a debt is subject to a condition precedent, the debt accrues if the debtor's breach prevents satisfaction of the condition. No authority along those lines binding on this court. And up to a point, the sellers don't really suggest that there is. They refer to a batcher, of course. That's first instance. It's not binding. It's the closest you will find in the case law to judicial endorsement of the general principle. It's not binding in this case. Palomino and Leyland and Corey, neither of those cases state the proposition in terms. And I'm not sure that my learned friend really suggests that they do. What he seeks to get from them is more a case of hint and allusion. And here is our case clearly endorsed in a judgment. The closest you get is Lord Justice Ricks's interpretation of Lord Watson in McKay. Although that is a decision of Lord Justice Ricks, he's sitting in first and finishing off a case he tried as commercial judge. McKay and Dick itself, it's a House of Lords authority, yes, but it's a Scottish appeal, and Lord Watson is applying avowedly Scottish law. It's not binding on this. And indeed, in fairness, the sellers give rather less prominence to McKay and Dick in this court than they did in the arbitration or before Mrs. Justice Dias. The foundational case now, it's no longer Lord Watson's speech in McKay and Dick. It's his son's speech in Palomino. Keeps it in the family. That is now the foundational case. It is said in Sellers' Skeleton at 24, page 102, the principle is actually established by a decision of the House of Lords in Palomino. Now, I would submit that what is immediately striking about Palomino in the context of that rather ambitious claim for it is how very, very short the relevant passage in Lord Sankerton's speech is. It's a bit less than a page and a half. I do submit that if Lord Sankerton really did intend to establish some significant new principles, one would reasonably expect him, one, to make clear to his audience that that's what he was doing, and two, to set out quite carefully the rationale and basis upon which he's doing it. I do submit that the very brevity of that section of the speech indicates that Lord Sankerton had no intention of innovating.
Well, he says that. He says unnecessary to cite authority.
Right.
He treats it as something well established.
He treats it as something that rests upon orthodox authority. He's not seeking to establish a new proposition in my submission. That's clear. And then one has to ask, well, what is he thinking that's orthodox? Now, it's not very clear because a criticism can be made that this section of his speech is so compressed that he does not very clearly articulate quite what he had in mind. He throws in some fairly broad propositions from existing cases, but quite in terms of analysis, he sees them applying to his case. He doesn't really articulate. But I do submit that looked at correctly, Panamina is a case of debitum in praesenti solvendum in futuro, and it is an illustration of the principle would have been established at the time that failure in the machinery of payment does not defeat the creditor's rights. It is quite true that Lord Sankerton does not say that expressed in terms, but on the other hand, as I just said, his speech is so short, he doesn't really expressly in terms articulate his thinking on any analysis. But if one looks at the contract in Panamina at 106, Clause 7, the payment for the repairs is on the ordinary commercial basis, which is basically cost plus various percentages. And then just by the hole punch, the bottom hole punch, payment shall be effected as required. I'll ask your lordship and ladyship to note that word, as required, by the repairers on the basis of cash against expenditure during the progress of the work. I ask you to note that. Ascertain balance on completion, and then come the certification clauses. Now, I submit that those provisions indicate that this is a case in which the shipyard earns the reward for the work on an ongoing basis during the progress of the work, as the work is done and as the costs are incurred. My learned friend yesterday posited, well, when does the debt accrue? And I submit it's diem per diem, as freight accrues as you discharge the cargo. It accrues as the work progresses and as you incur the costs. That's the basis of payment. This is not a Cutter and Powell entire contract which contemplates that the shipyard isn't going to get paid anything and have any rights until it completes all of the work and hands the ship back. It's not a lump sum contract for a single payment which is only earned on the completion of the work. Now, my learned friend refers to Dunlop and Hendel as though it somehow establishes an abstract principle of law that a shipyard doesn't have any accrued rights until it's completed the job. But it's not a question of abstract principle of law, clearly, it's a question of the interpretation of the particular contract. And Dunlop and Hendel is very clearly a Cutter and Powell entire agreement. It's a lump sum contract, a different sort of contract. Lord Justice Goddard, Lord Chief Justice Goddard, is quite clear about that in my submission. If one goes to 166 in the number, he says, by the first hole punch, it's a Reba form of contract. And then at the bottom of the page, going over the page, he sets out the certification and payment clause, clause 24. What one notices there is that the interim valuations are not to be made as required by the builder as the work goes on. They're to be made whenever the architect considers them necessary. And if the architect certifies, then after the certificate, the builder is entitled to payment. And the Lordship will note what Lord Chief Justice Goddard says after the quote is that is dealing with a case where there is a lump sum contract and interim payments are to be made. It is a lump sum contract. It is a Cutter and Powell contract in principle. That becomes clear from 1107, 169 of the bundle, where Lord Chief Justice Goddard says this: it's the advantage of the garnishees, that is the yard, to have the contract providing for certificates in this way, because otherwise they would have to deliver everything and do all the work before they would be entitled to anything. The structure of the contract, the basic structure of the contract in Dunlop and Handel is that it is Cutter and Powell entire agreement lump sum. But there's a provision for payment as you go along, which is to the advantage of the builder because it means they don't have to wait. It is what, as Lord Chief Justice Goddard rightly calls it back at 167, a drawing on account. It's effectively an advance on money which is not technically earned until the lump sum is earned. And then Lord Chief Justice Goddard says this: in order to get payment, he must get a certificate from the architect, and it's generally left entirely to the discretion of the architect as to when he certifies. And that reflects what's said above, that when the architect considers necessary. So the structure is that this is a Cutter and Powell lump sum, with provision for interim payments, but not as of right, as to an accrued debt. But at such times, and in such amounts, as the architect, in his discretion, decides. And that helps the builder with the cash. But it's not a matter of right. It is a matter of the architect's discretion, and it doesn't alter the basis of the contract that it's a Cutter and Powell entire agreement for a lump sum. Now, that is just not the contract which is being described in Panamida at 106. Not a sensible reading that payment will be effected as required. That suggests a matter of right, not of discretion. It's a right in the builder. During the progress of the work, it is not a Cutter and Powell contract for payment on completion. And it's not a lump sum, it is costs plus on costs which are being incurred as the work progresses. So on the face of it, until you get the certification clause, it's absolutely a matter of right. The demand be paid now. And then it's qualified by the certification clause, which comes in bottom of 106 over to 107. And the certification provisions are plainly, in my solution, they're there for the ship owners. They give the ship owners the opportunity to have their surveyor look at the work before they have to pay, and to have the ministry check the figures before they have to pay, and therefore to say, well, actually the work isn't satisfactory, and we're not going to certify it unless and until you put it right. Now that's the answer to my learned friend's commercial absurdity point, which was suggested yesterday. It's just absurd, he says, to suggest that the builder acquires an ongoing right to an accrued debt, because the work may be complete rubbish. But if the work is complete rubbish, then the surveyor is entitled to say, it's not right, and I'm not going to certify it until it's put right, and the owner is then entitled to say, I'm not going to pay until it's certified.
Well, that's looking at the quality side of it. Let's look at the expenditure side of it. Suppose that the board do not certify that what's being claimed does represent expenditure in accordance with the commercial terms. What debt has accrued?
That would be a question of adjustment for debt, my lord. The same point might arise in relation to quality. The way of looking at quality is two. First of all, The engineer may say, I'm not going to certify this, it's it's not up to standard. Or
Leave that aside for a minute.
Or the ministry might
The
say.
ministry
The
say,
ministry might say.
you've claimed
it's not- it's not worth-
53,000, you've only spent 26,000.
Yeah, or it's not worth what you've done. Now,
What is the debt that has accrued?
the debt which would have accrued prima facie would be the costs plus, but the certification clause is effectively an adjustment clause. It can be adjusted downwards if the ministry so say.
But if the true position is that 53,000 has been incurred, what is the debt that's accrued?
Well, put the case that 100,000 has been accrued and the work's been properly done. And the ministry, by mistake, say, well, we've looked at the invoices, they only actually add up to 50,000.
Well, never mind by mistake.
well,
They refuse to certify,
Well,
and they say we actually are only prepared to certify that there's been 50,000
Yeah.
done.
Well, that, in my submission, that is not going to lead to the conclusion that they're only entitled to 50,000 if it's wrongful.
Why is the certificate a condition precedent to payment then? I mean, in what sense is it a condition precedent to payment?
It's a conditional precedent to payment in this sense, that if the machinery works, and that's the point, if the machinery works, because it's applied properly, then the builder, forgive me, the ship owner, is entitled to rely on it. So getting back to the surveyor, if the surveyor says, I'm not going to certify the work because it's a complete load of rubbish, and he's wrong about that, then that cannot have the effect.
But I'd rather you didn't keep going back to the quality question.
Well, okay.
I'm just focus for the moment on the certification of the expenditure.
If they say,
They've done,
We've done the maths.
as a matter of
and
fact,
it doesn't
they've
about
incurred expenditure of 100,000, or they've earned 100,000 in accordance with the terms, but what is certified is 50,000.
if it's wrong,
What debt has accrued? When?
100,000. Hard to see how a mistake or whatever, a refusal, misconduct.
So then, what function does the certification
The function,
clause take?
the function of it is that it postpones the payment until there's been an opportunity by the ministry to look at and review the figures, which is plainly for the benefit of the ship owner, because it gives them an opportunity to, for example, point out any just mistakes in the maths.
So it's a condition
And
precedent to payment, but it doesn't matter what it says. There just has to be a certificate.
well,
And if it doesn't accord with what the debt is in fact, then it isn't a condition precedent to
If-
payment of that debt.
if
Is that what you're saying?
if the certificate is issued, it says it's 100,000,
Mhm.
and the owner says, well, I'm just not going to pay, then the condition has been complied with and it's payable, and you can sue on the 100,000, and it will just be a liquidated claim of
Yes.
debt.
But
If they
the
certify for 50,
yes,
you can sue for the 50
yes,
on the certificate, but if it should actually be 100, you'll have a claim for the 100, but you will then have to establish that the certificate was wrong. You'll have to go behind the certificate. You won't just be able to say the certificate will say, well, actually, the surveyor got it wrong. He just got the maths wrong. It
Can
wasn't
you do
that.
that?
Well, it might be presumably you're saying it might be different if the contract said the certificate is binding on the.
If it was, if,
Is
you
the
do
final
sometimes
word.
get these that say they're final and binding, and they can be made final.
Does this
and binding.
not certificate, not contract, not say that?
Well, I
On
think
page-
it may in fact do so, my lord, in relation to the ministry certificate, if I remember rightly.
Yes,
But if it says final and binding, it's final and binding. yeah.
final and conclusive, and not be questioned except as
Well,
regards
there
any.
we are.
any
So
That's-
what
other-
debt? So what debt has what debt has accrued?
What has accrued is in principle, because this is what the contract says, is on a cost plus basis, but it will then in effect be adjusted down if that's the decision of the surveyor and the certificate.
So it's not a debt, it's a.
Well, it's a debt that's subject to defeasance, one way of looking at it, or reduction. The debt's subject to adjustment. Of course, if it really is 50,000, and in claiming 100,000, then they've just got the math wrong, then it will be 50,000, not 100,000. But if it's 100,000, then in principle it's a per diem being accrued, But the effect of the certification clause is to adjust it down.
So that the ministry certificate is not a condition precedent to payment, it's a condition subsequent or condition defeasant to
Well,
the right to the debt, to the accrual of the debt.
in a sense, it would perform both functions, my lord. In terms of quantum, in terms of quantifying the debt, it has a defeasance effect because you write down the quantum, but in terms of the right to payment, you have to get the certificate before you can claim the sum that's in the certificate. Your lordship may be right. This is perhaps what the judge had in mind. As your lordship will see that the judge's view was that the debt accrues on the issue of a certificate by the ministry. Now, that may be another way of looking at it, which may avoid the point that your lordship's just been putting to me. So that the debt doesn't accrue until that phase, but once the ministry is certified, as they had done in this case. In my submission, that is adding an unnecessary refinement. It is possible to give effect to what the contract appears to say, which is that it's a right to payment accrues diem per diem as the work progresses. But perhaps perhaps that's what the judge had in mind. But either way, the contract is not phrased in a way that the certification by the surveyor is a condition precedent to accrual of a right in debt. And
How do you,
in
dis-
some
how do you
ways,
distinguish between a certificate which is a condition precedent to accrual and one which isn't?
and one which isn't? It's a question of the construction of the contract, my lord.
Yes, but in this case, I mean, what is it which enables you to say, as you have just said, the certification by the surveyor is not a condition precedent to the accrual of the debt?
But
You
the way-
clearly can't sue for the debt so long as the surveyor's certificate is properly outstanding. Well, according to the House of Lords, you can sue for it if the certificate is wrongly outstanding, i.e. that the appellants have stopped the surveyor from doing it properly. What is it that enables you to tell whether this thing which stops you suing for the debt is or is not a condition precedent to the accrual of the debt?
The nature of the reward and the distinction between Dunlop and Handel. If it's a Cutter and Powell case, then certification or no certification, you don't have any right to reward until you've completed the work. This is not a Cutter and Powell case. And the description of the right to payments as required as the works progress, just on the face of it, indicates a right to reward accruing as the work progresses.
And in this case, the right to the reward accrued irrespective of the quality of the work. You say.
Well, if the work is defective, then you'll have a Mondle and Steele standard form of abatement, one imagined.
So therefore not.
Well, your
Doesn't-
lordship might
doesn't
say that
accrue.
in any case, for example, where there's a sale of goods and they're defective.
Yeah.
The way it's
But
put
how-
is that the debt accrues, but it's then subject to a writing down in the quantification. It doesn't mean the price isn't earned. It doesn't mean that there's not a right to be paid. It's simply subject to the common law's effectively answer to the set-off, it's a deduction.
But I thought, I may be wrong about this, I thought the doctrine of abatement was one which invaded the existence of the debt, not set it off.
It doesn't.
It prevented
avoid-
the debt being a debt in
It-
anything more than the abated amount.
That's the point, my lord. It abates the amount. It doesn't prevent it being a debt. It affects the quantum of the debt.
Well, quite. But if we're
not a
talking
case
about
where
if we're talking about an accrued debt or accrued rights in debt, the amount of those accrued rights is just as important as the existence of any of them.
I see that, my lord, but there are these cases one sees where the provision is made for the what would otherwise be the quantum, the liquidated quantum, to be adjusted, whether it's by an abatement or by an express contract terms here. Now that does not mean That does not transform the case into a Cutter and Powell entire agreement where you just have absolutely nothing until you get a certificate.
No, but that doesn't avoid the problem of having to identify what the accrued debt amounts to at a stage which, on your case, does not involve any investigation either of expenditure or quality. It just seems counterintuitive to me.
Well, my lord, it is the way it's expressed in the contract and the existence of the adjustment clause or potential abatements does not affect what the contract says and does not, in my submission, affect the accruing of the rights. But as I say, the alternative way of looking at it may be, as the judge said, that well, perhaps it doesn't accrue until the quantum's been certified by the ministry. That was the judge's analysis.
I'm sorry to be difficult about this, but I'm having difficulty with this. I understand that you can have contracts where what you're paying for is the completion of something. If you engage an author to write you a book, he's not entitled to be paid for the first half. He's only entitled to be paid once he's finished the book. And that's true, even if there's an agreement that you pay him in instalments as he goes along. I mean, ultimately, his right to the price depends on completing the book. And the same is true of all sorts of other things. And as you say, it's clear the same was true in the building case we looked at, because it's a lump sum contract, and that means you don't get paid for the first half if you only do half the work. But why is that not the case here? Because here, the obligation on the repairers is to finish the work to a particular standard, and it's no use to the ministry or to the ship owners if you do half the work. Now, it is true that the contract provides for payment as you go along, and you can see that that's a cash flow thing. But that doesn't mean that you're entitled to keep it. Suppose the ship owners had done half the work and then gone bust, they won't be entitled to keep the money they've had.
For the work that they've done?
The work they've done, which is of no value to anybody because it's not finished. I mean,
So the work they've done half the work.
well, how,
Half the works can be completed by another yard. Yes, they are going to get paid for it in my submission. That's clearly what the contract contemplates.
well, what I'm struggling with is how do you tell from the wording of the contract? All the contract says is you have to do the work and we'll pay you cost plus, and you can get payment by certificates as you go along. How do you tell whether that payment by certificates is because you've actually accrued a debt and the certificates are just conditions as to payment, or whether it's payments on account of what's ultimately due to you? I don't.
It will be, obviously it will be a question of construction, but I do draw a very clear distinction between this case and the Dunlop and Handel. With the Dunlop and Handel, it's lump sum earned at the end and no right to interim payments as you proceed. It's a question of discretion and expressed as such in the architect. And you compare the language here, it's not lump sum. It's not something where you have to have completed the work to earn the reward. You are being paid for the costs which you are incurring as you incur them and do the work with an uplift. And the payments to be made as the work progresses as required. Now that word required in my submission, and as the work progresses, those points I submit as a matter of construction to a very different structure, to the structure in Dunlop and Handel. And in my submission, it's not realistic, looking at the terms, to think that if, in your lordship's case, they went bust when they'd done half the job, the owners were going to get half the job for free.
Well, that's what happens in a lump sum contract, building contract.
What happened to the lump sum contract in Cutter and Powell?
Yeah.
And that may be why shipyards are not prepared to contract on a lump sum Cutter and Powell basis.
Okay,
And they didn't, in my submission.
thank you.
And the obligation to complete, the express obligation to complete the repairs to a particular specification so as to get the certificate would simply involve a breach in those circumstances, which would give rise to such damages as could be proved, you say.
If it is interpreted as being an obligation to obtain a certificate, rather than an obligation to obtain, rather than an obligation on the...
We've got it at the top of the page in clause 6.
Yeah.
Shall be completed by them without any delay. proceeded with in accordance with the said specification. All such repairs shall be completed by the repairs in such a manner as to enable the said vessel to be granted the permanent certificate of seaworthiness.
If they're in breach of that, then they're in breach of that.
Then there's a damages claim, but that doesn't affect their right to be paid.
No, because the payment right is in separate clause 7 in the Lordship sees how it's put. Now, my lord, in a sense, the whether or not there was any accrued right to the reward, in my submission, there's a bit of a hint in the way question 4 is phrased. 108. Lord Frankerton says that all these questions he's going to deal with, he takes them conventionally formatted, conveniently formulated in the appellant's case, though in a different order. So these are the case questions I put. And your lordships, you see question 4. Now, in a sense, question 4 is not about liability, it's about quantum. There's no suggestion that without a certificate they're not entitled to be paid for the work. The owners must have realised that if they ran that case they were going to be laughed out of court. It's a question of what are they entitled to be paid.
Well, because it was a claim for the contractual price, not for a quantum merit. That's why that's expressed in those terms. Others
Well,
once entitled to recover the amount claimed in the action, not merely such amount as may be held to be a reasonable price.
It's a binary question as to whether the right is a right to be paid the liquidated amount or a quantum merit. The answer is going to be it's either a quantum merit or it's a liquidated amount. It turned out it was a liquidated amount, but it wasn't being suggested. So they weren't entitled to be paid at all.
But so what? So I'm not understanding why that has any bearing on the...
Because, my lord, it shows that it was not being argued that without the certificate they just didn't do it.
No, but equally, what is recognised, namely a quantum merit, does not depend on there being an accrued debt, does it?
But, my lord, if those in the recent case in the Supreme Court, the Barton case, if I remember rightly, if the correct analysis is that you've not earned your payment according to the contract, then you can't claim a quantum merit instead. You are bound by the contract. So if the right interpretation of the contract was they didn't have any right to be paid at all without a certificate, then they just wouldn't have any right to be paid at all without a certificate, and quantum merit wouldn't come into it. Right? It's clear from the way the question is formulated that the owners didn't have the nerve to argue that they weren't entitled to be paid at all. Clearly a concession that they were entitled to be paid, something had accrued, and if you accept that notwithstanding the lack of a certificate, then some right to be paid as accrued, in my submission, it's not a very large step, indeed more or less inevitably follows. You're treating the certificate not as a condition precedent to an accrual, but as something else. It's a right to payment. And then it becomes mere machinery. But it's not being put that they simply didn't have any accrued right at all without a certificate. And indeed, in my submission, when you look at the contract wording, it couldn't seriously be put.
Accrued right to what?
Forgive me, my lord, the
Accrued
right of the builder.
right to what?
The right of the builder is either to a quantum merit or to the money as debt. That those are the alternatives proposed by question 4.
Right. And assume that it's correct that to treat a right to a quantum merit as an accrued right. How does that help us?
What it shows is that it was not being suggested by laws that they simply didn't have a right to pay without a certificate. That was being argued. If the certificate was as a condition precedent to the accrual of any right at all, then the logic would be you haven't got a certificate, you just can't have anything. But that wasn't even being suggested. There's an implied acceptance that they've acquired a right to be paid.
That may have been a tactical. I mean, at first instance, it appears that that was the shipowner's position, that because there was no certificate, it was a condition precedent to the right to receive any payment.
Perhaps it was, my lord, but tactical or not, it was in my submission realistic. Because they realised that they were not going to get very far with an argument that there's just no right at all without a certificate. But if you accept that there's some right to be payment, some right to accrue, certificate or no certificate, And I do submit it more or less follows from that you're saying that the certificate is really just about machinery of payment on accrued right, not about accrual of right to be paid. The other point, my lord, and my lady, I make about the case, I've already mentioned this, is that what is said about Panamina in my learned friend Skeleton and yesterday is that the ship owner, quote unquote, in breach of contract prevented the certificate from being issued. That's in the Skeleton at 32.2. Now, that's put that way because it harmonises with the general principle. And one can understand, perhaps, the thinking, given that Dr. Telfer was both the president and the director, as well as the surveyor. I could perhaps understand the thinking that his obstructive attitude amounted to a breach of contract on the part of the ship owners. And indeed, at first instance, and in the Court of Appeal, it was held that he'd wrongfully colluded with the ship owners. All of that was said by the House of Lords being wrong, but it's notable that Lord Thankerton doesn't actually say it in dealing with questions. Perhaps he thought it, perhaps he did, but he doesn't appear to regard it as critical to the conclusion. And that again brings me back to the point, if one looks at it in terms of accrual and machinery of payment, orthodox principles, and the Karen Vatis shows that breach of contract isn't an essential ingredient.
Why then does he say at the bottom of 435 that it's almost unnecessary to cite authority to establish that such conduct on the appellant's part absolves the respondents? He doesn't say the machinery is broken down, so you can ignore it. He says the appellant's conduct means the respondents don't have to get a certificate.
Yes.
That does look like if you do something wrong, then you lose your right to insist on a certificate.
Well, what he says is it was the imposition of an illegitimate condition precedent. He doesn't say that doing that was a breach of contract. He doesn't seem to think that it matters. But if it's the imposition of an illegitimate condition precedent, then that is a breakdown of the machinery. The machinery wasn't working. That was the whole point of the question. Questions 1 and 2 was Dr. Telfer entitled to say that he wasn't even going to consider certifying unless he was providing information about costs. And the decision all the way up was no, he wasn't entitled. That wasn't the construction of the contract. He was only entitled to think about quality. And so by imposing this illegitimate condition, he was making, in Karen Vass's terms, the machinery was breaking down. It wasn't working as it should. It wasn't working as the parties intended. It wasn't working in accordance with the meaning of the contract. Now, it may have failed in circumstances which amounted to a breach. It may not. I just make the point that Lord Thankerton doesn't appear to think that that's a critical consideration. And if it's a case of an accrued debt with a condition of payment, then it isn't a critical part of the analysis. The questions are accrued debt and breakdown of the machinery, not breach. In point of fact, compared to the first instance in the Court of Appeal, the House of Lords rather exonerate Dr. Telfer. They say that all the allegations of collusion shouldn't have been made. Set all of that aside. Most unfortunate. He had a horrible time in cross-examination.
All the fault, Mr. Devlin.
Yes. Or Mr. Pritt, who I believe was not a popular advocate with the House of Lords at the time.
Is that a convenient moment?
Yes,
Are you?
but I'm just going to check whether there's anything more I want to say about it, my lord, because otherwise I'll be coming on to Corey and it will be a convenient moment if I just check the note. Oh yes, the other point I make is this, and it's true of some of the other cases, and it's true of the Luxor case, and my lord, Nugee used it against me. If there was a breach of contract in Panamina, then on the face of it, it looks like a case where a claim for breach of contract, the quantum would be exactly the same as what would have been payable if the certificate had been issued. So that
Yes, and there was in fact a damages claim, and there was a finding at first instance the work had been done to that
Unsatisfactory.
satisfactorily to that value.
Yeah,
But
so
but
that
that
may
wasn't-
be another reason why the judgment is quite short, because
might-
to some
that-
extent it's an academic debate in Panamina.
it could have been decided on a different basis.
Could be decided, whichever way you put it, they were going to win,
But
is the point, my lord, and that may explain why it's very short. It's not a critical point. My lord, that would then be a convenient point to come back and deal with Corey after the adjournment.
yeah, speaking for myself, I'd be grateful if you'd take me back to Hotham, because I think the unspoken premise in your submission about Lord Thankerton's speech is that what Mr. Justice Ashurst was dealing with in Hotham was a condition precedent to payment, not a condition precedent
But
to
my lord, yes,
an
I'm going to say
accrued
something
debt.
about Hotham and Roberts after I've dealt with Corey. Or perhaps I
Take
should do it the other way round.
it in whichever order
Okay,
you
my
like.
lord, I do
Yes.
have it in mind, yes.
Yes. 2 o'clock.
Goodbye.